Good afternoon, guys, and welcome to today's edition of The Law and You. I am your host, yours truly, Attorney at Law Shellon, Washington, licensed in my home country, Guyana, in Trinidad and Tobago, and in the state of New York. I bring you today's edition based on the needs of some people, clients, just people generally calling in for advice on specific issue. So that sometimes determine how I bring these series or events to you. So this afternoon, we're going to be speaking about something that is very interesting. We're going to be speaking about a power of attorney versus guardianship, or when is it best to have a power of attorney versus applying for guardianship. We're going to be discussing that today. How do you know which one is best and when to do it? This is more applicable for the state of New York, and the power of attorney, when we discuss it, we'll discuss the type as it relates to Guyana also. But let's get into it, guys. I'm excited to bring you this edition. So, what is a power of attorney? Some of you know what it is, so I do not have to go into great details to explain because a lot of you already have one, or at some point in your life, you would have given somebody a power of attorney to be used for your assistance or for your benefit, whatever the case might be. Anyway, guys, so a power of attorney literally give or designate an agent to act on your behalf. So if you know anything about the principal and agency relationship, it's sort of that. You're giving somebody authorization or authority and you're telling them, hey, I would like you to act on my behalf. Now, there are different types of power of attorney. They can be limited, which means it's very restrictive, and it's only for a particular purpose that you would like the person to use it for. So, for instance, somebody might have a car and they might be living in New York and the car might be in Guyana, and they might not want to go to Guyana themselves to sell the car, and somebody might be interested in purchasing that car and they're willing to sell it, but they don't want to leave New York to jump on a flight to go to Guyana just to sell a car for, let's say, 2,000 US dollars, because of course that's going to take up a big chunk of the money in just the transportation to go to Guyana and sell the car. So in that case, what do? You create what is called a power of attorney. You create an principal agent or agency relationship where the person who owns the car give a power. You could give it to the purchaser, the person who's buying the item from you, and you give that power to that person, limited and restricted for the specific purpose, which is, I'm telling you, I just need you to use this power of attorney specifically to sell or for you to purchase this car from me. So the power of attorney is going to be tailored to a limited purpose for that person to buy that car from you. Or you can give it to anyone. It doesn't necessarily have to go to the purchaser. You can also give that power of attorney to a friend, a family, anyone that you trust who is going to Guyana, and you want that person to act on your behalf in that transaction, which is to sell that car on your behalf. So that's what a limited power of attorney is. It gives a person specific powers, limited powers, that is, to act on your behalf in a specific, narrow, tailored situation. Okay, you can use a power of attorney to sell a property also in Guyana or in New York. You can use that power of attorney for that limited purpose, for the person to act in your place as the seller. Next, other than the limited power of attorney, there's something also called a general power of attorney, which you can give somebody and give them unlimited power to act, virtually doing everything on your behalf. Now, in the United States, the power of attorney, if you give a power to someone, don't believe that that person will be able to use that power to make medical decisions for you. They cannot. You would need a living will, or you can have a medical proxy for that purpose, but you cannot use a power of attorney to make medical decisions for you. So in other words, a power of attorney in the United States could be used to do anything else. It could be used to sell your property, to manage your assets, collect rents from your tenants, any number of things it can be used for, save and accept medical decisions on your behalf. And you have to be careful when you're giving someone a general power of attorney, because literally that person could use that power to do anything within the realms, the four corner of that document. They could bring they could represent you in lawsuits. They can bring lawsuits against someone on your behalf. They can sell a property. They can mortgage a property. They can take a loan. They can do any number of things on your behalf with a general power of attorney. So you have to be careful when you're dealing or when you're within the realms of a power of attorney that is general. And believe you me, I've seen situations where people from New York give people in Ghana general power of attorney, and they use the power to sell the people's property. So the people are expecting that the property is home and the person is managing it and they're doing whatever they're supposed to do. But then, surprise, big shocker when they get there and they realize that the power of attorney was used for something completely different from what they anticipated. And they forgot that it was general. So therefore, if it's general, the person could literally use it for any situation other than making medical decisions for you. Even the one in the United States, the one in Guyana, the power of attorney again is also general. You look at the four corners of the document and you see it gives so much liberty and so much power to your agent that you have to be careful with, and make sure if you're going to give a general power to somebody, that's someone that you can trust, and you know that they're not going to use that power to your detriment, but they're going to use it to do whatever it is you expect them to do. In some instances, I've used power of attorney, created it actually. I haven't acted myself as a power or as an attorney on behalf of any of my clients, but I've created it for several clients. And in some instances, I've explained the parameters and the length and the breadth of it so that they know it's general. And if they do give a person such a general power, the person literally can take your property from under your nose and sell it, which I've seen happen. I've seen people give it right here in the United States too, and the person use the power to take a mortgage. There's a case that I've seen where the woman gave the daughter the power of attorney, and the daughter used it to put mortgage on the mother's property, and the other siblings were completely oblivious to this until the mother died. Then they recognized that the sibling who had the power used it and obtained mortgages, put debts on the property, so that when the mother died, there was less assets available to distribute between the siblings, because the mother did, of course, left a will. So you've got to be careful. People can use that power to sign over deed, do a number of stuff. So be careful with who you're giving a power to. And in instances, you can have successive attorney, or you can have multiple people serve as your agent at the same time, or attorney. You call it that agent or an attorney. Either words are used interchangeable. You can use multiple people to serve that function simultaneously. And the reason is, if you put them to act jointly, then nobody is going to do something that the other person didn't know. But when you have one attorney acting, then nobody knows what that person, sometimes not even the principal who give the power to the attorney, is unaware of what is happening. And the person could be acting to the person's detriment. They could be clearing out your bank account. They can be mortgaging your property. They can be taking any number of steps which is detrimental to you. So you have to be careful. Make sure you trust whoever you are giving a general power of attorney to. Now, the question is, could you use a general power of attorney versus using a guardianship? You ask yourself, when is the guardianship appropriate? Like I said to you before, the general power of attorney could be used for any situation whatsoever. The guardianship is a little bit different. Now, the power of attorney is usually executed when the person is of sound mind. They understand what they're doing. They know everything, and they don't lack cognitive function. So, for instance, they don't have Alzheimer's, or some disease that affects the mind or the memory. So even if they do, the power of attorney could still be executed at the time when the person is lucid and of sound mind. But generally, a power of attorney is used when the person is of sound mind. Now, if the person lacks the mental capacity, the necessary mental capacity, and it's an alleged incapacitated person, then the most or best option is to go for a guardianship if you want to make decisions for that person. So a lot of people have parents who lack the ability to act independent. Their cognitive function is declined because of Alzheimer's or whatever mental defect they might be suffering from. In that case, it's advisable to just go and get guardianship, apply for guardianship at the court. This is an application. It can take a while, but you have to file a petition for guardianship. And there's two types. You can apply for guardianship of a person's property, or you can just apply for guardianship of the person to make healthcare decisions on behalf of that person, or to do whatever, as it relates to the person's health. But the guardianship, you can also manage the person's asset. So the same thing that the power of attorney doing, the guardianship can accomplish it, but in a better way, but in sort of a more restrictive manner. Once you apply for a guardianship, you're kind of restricted. A lot of people they're under the misconception that if you get a guardianship, you can just have access to a person's money. But if you ask a court to appoint you as guardian over a person's assets or property, you're still answerable to the court. And a lot of things that you do, you have to provide accounting for the person's asset, especially if it's an estate with a lot of money. If it's a small estate, nobody really cares, because smaller estates, nobody monitor those estates a lot. Those estates generally, even though the court appoints the guardian, because there's not much there, even though you have to maintain the accounts, there's not much to keep reporting about, because there's not going to be anything left over when you pay the person's monthly expenses. There are instances where a person is on, let's say they're on their social security check. So on a social security check, all they're doing every month is paying the person's bill, making sure that the person's groceries or whatever they need is taken care of, their everyday general needs. But if it's an estate with millions of dollars, that trustee is going to have to maintain proper accounting and report regularly so that the court is aware of what's happening and nobody is squandering the estate. The estate asset is not being used in any malicious way. So if you ask yourself, should I get guardianship versus should I get a power of attorney, that's going to be based on the person's health status. Another thing is, if a person already has a will, right? If a person already has a will, and then after that, there's no cognitive decline, the person still have all of their mental faculties, the power of attorney could be used to transfer out the assets while the person is still alive. So let's say the person still they're aware of their surrounding, they're aware of their environment, their mental faculties are intact, but let's say the person knows that they're declining health-wise and the person prefer to have the assets transfer out before they die, because, I've said this multiple times up here, under a will, there are costs that you will incur in order to settle an estate, including filing for probate if the estate is over a certain amount, paying estate taxes. If it's under a certain amount, then you don't have to worry about estate taxes because there's none, right? But if it's over the threshold, if it gets to the millions, you know that you've got to find a way to pay the taxes if it's required on the federal or state law. Now, like I said, the power of attorney, if the person knows that, they have a will, a secure in place, or maybe things change. A lot of times people make will and then the circumstances change. Like maybe one of the beneficiary pass away, or, something, the executor is no longer there. Something happens. And if that happens, what could happen is the power of attorney can use that general power and transfer the property either to the beneficiaries or do something with it before that person died. And one of the things that impedes older people with assets is the fact that a lot of times they need to use welfare, social services from the state in which they live. And a lot of time those social services comes with a cost, and that the city that you living in, that you take those social services from, they're going to put a lien on that property if you're over, I think, over the age of 65 in some cities. They're going to put a lien on your property. So then when you eventually die, whatever amount you use in, let's say you were in a nursing home, you're in a hospital, whatever you use, and it's charged to your Medicare, then your Medicaid, I think it's Medicare, when it's charged to that, then, there's a lien on your property or a lien on your assets for that amount of money to be paid back to that city or to HRA or, the welfare services that you use during your lifetime. So a lot of times it makes a lot of sense to use the power of attorney to transfer out the assets while the person is still alive, and let the gifts that pass under the will, it will lapse. But even if the gifts under the will lapse, it's not a big deal, because the beneficiaries would have already got access to those assets during the lifetime of the testator or the principal who donated that power under the power of attorney. So the power of attorney, I would mostly recommend using a power of attorney a lot of times. In only cases where the person, like I said, is incapacitated, they don't have the mental capacity, they're not aware of what's happening. In that case, I said the best thing is to do is rush to the court, apply for guardianship, and clear the air on that. There's a lot of times when people obtain power of attorney when they shouldn't even have obtained a power of attorney because the person lacked the mental capacity. I know a situation where, one of my clients, she was married to this guy and he developed Alzheimer's. And after he developed Alzheimer's, there was no way, he couldn't even remember who she was. And his daughter took him from the wife, took him away, removed him from the state he was in with his wife, and took him into her home. Now, after that happened, the wife couldn't even see her husband. She had no access to her husband because the daughter had stepped in. And the daughter went and get a power of attorney. I'm not sure which notary executed that power of attorney, because clearly somebody with Alzheimer's, there's a very high probability that they would not be able to execute that power of attorney. So you got to be careful when you get in a power of attorney that the person who is executing it, the principal, has the capacity. But anyway, it was executed. And what happened is the wife was left out in the cold. I told the wife the best thing to do, the best case scenario, is apply for guardianship, because once she would have done that, then it would have gone before the court. The court would make a determination based on the medical as to whether or not her husband had the capacity to even make his own decisions independently or even execute the power of attorney. And then if the court found that he lacked the capacity, then the court would have granted the guardianship, and the daughter's power of attorney would have no effect after that because she couldn't make decisions anymore. The guardianship technically overrides a power of attorney because the guardianship application is based on actual evidence. The court hears evidence of the person health records. The nurse or whoever that treated or cared for that person could provide an affidavit, or they could be testimony, actual testimony, to determine whether or not that person has the capacity to make decisions for themselves or their property. There's times when people just ask the court to appoint a guardian for their property and not their person. Like I said earlier, the guardianship could be for both, for your person and for your property. In most cases, people apply for both person and property, because person just means you could make healthcare decisions for the person. You could determine which nursing home the person go to, or if they go to one at all, or if they stay home and receive treatment from home. And people need to be careful when they're, giving or allowing a person to be their guardian. In cases where people don't have any family, no spouse, no children, oftentimes the court chooses for you who is going to serve as your guardian. And And if you don't want the court make that decision, the best thing is you select a person and tell the court, this is the person I would like to serve as my guardian. And if that person complete the training, then the court is likely to allow that person to serve as the guardian. There is a lot of requirements to serve as a guardian in the state of New York. And if you're interested in serving as one, you have to make sure you learn the rules, you understand what is required of you, what you have to do. Okay. Now, as it relates back to the power of attorney, like I said, be careful who you appoint. Make sure you're comfortable with the person. Make sure you know who that person is. The power of attorney is not like a trust where you put a trustee to act for you. That's why my preference is always a trust when it comes to assets, and a guardianship when it comes to putting somebody to act as a decision maker where your health is concerned, where you don't have any children or a spouse. The reason is the court has control over that guardian. The court appointed guardian is controlled by the court. But a person who you just, anybody who's not appointed by the court, they can act any particular way. And there's no checks or balances to tell them, like, you shouldn't make this decision, or you could make it, or there's no restraint. In other words, they can act in any way that could be detrimental to your own safety or your longevity. So just be careful with who you're appointing if you choose to have a guardian appointed. And even if it's not your choice, if it's for a parent or some incapacitated relative, just make sure that you have a saying and you know who's being appointed, and that the person is capable of making decisions that is beneficial to your relative. Now, the safeguard is always, like I said, is the trust, because the trustee, you could have numerous trustees making decisions for you, not just one under a trust. You could appoint multiple trustees to serve at once. And then you have successive trustees who take over once those trustees are no longer able to serve. And a trust could have multiple restrictions, so you don't have to worry too much about your assets, versus when your asset is being managed by a trustee. Not by a trustee, by a guardian, I'm sorry. A guardian that's appointed by the court to manage your assets. Usually the court just choose one person and appoint that person. But like I said, there's checks and balances that the court puts into place. So no guardian will be able to just take your money and go with your money and that's it. It'll be a lot of restrictions, checks and balances in place, and all these things to protect you and your assets. Guys, thank you for joining me today. And if you're here and you've been watching this live, I would like you to smash that like button and share the live. I usually encourage people every week you come, click on the like button and share the live. That way, people who need the type of content that I'm producing will be able to see it, and they'll be able to get the kind of help they're looking for. And if you are in need of legal advice, my number is right on the screen, 718-877-3100. You can call that number anytime, Monday to Friday. We're available in the office 9 a.m. to 5:30 p.m. You call that number if you're seeking legal advice. We provide a free 15 minutes consultation to our clients. After the 50 minutes of free consultation, if anybody needs further assistance, then there's a consultation fee. But if you're in need of free consultation, just call the number 718-877-3100. And don't forget, as always, press the like button, guys. That's how I know that the content is reaching the right audience and that I need to continue to produce a particular type. Not only that, guys, you also need to make a decision as to, you can email, you can send me messages, any content that you would like to hear on this live. You send me a message and I will produce that content for you. If there's a particular legal issue that is bothering you, troubling you, you need advice, give the number a call. For some of you who would like to have live questions, not consultation, because we cannot do consultation on a live because of the attorney-client privilege. But if you have legal questions and you don't mind discussing it here on a live, you can call the number 718-877-3100 right here while I'm producing the show, and you can ask your questions and I will provide it to the best of my ability. If I don't have the answer, then I will encourage you to just call into the office and let's do a consultation there. Well, guys, once again, I thank you so much for joining me on this Saturday afternoon for my edition of The Law and You. Today, we have discussed a power of attorney versus a trust. And for those of you who believe a power of attorney or a trust is best for you, if you need to create a trust, give me a call. The healthcare proxy is usually done at a hospital or the healthcare facility where your relative is. If your relatives still have mental capacity, they can execute that of their own free will. But the guardianship is done, an application through the court, or the power of attorney is just a document usually prepared by an attorney and you execute it before a notary public. So if any of this content applies to you, again, you can call my office 718-877-3100. We're available Monday to Friday, 9 a.m. to 5:30 p.m. Thank you so much, guys, for joining me. And I hope I'll see you guys again. And invite your friends, family, whoever to join this live every Saturday at 4 p.m., where I bring you the law and you guys. Don't forget, click that like button and share this live. Share it so that people who are in need of this content will be able to see it. Thank you, and I'll see you again next Saturday at exactly 4 p.m. Do enjoy the rest of your Saturday and Sunday tomorrow. And for those of you who are celebrating Veterans Day, happy Veterans Day to all the veterans. And may you continue to enjoy the rest of this weekend. Thank you, guys. See you again next Saturday at 4.